All right, Ms. Wilson, how we proceed?
I think we're ready on Senate Eve.
Senate Eve.
He should be on Zoom.
All right. So Thomas, Senate Eve, we'll call your case first. So we're on the record. Who's this lawyer, Ms. Wicks?
Yes, I'm on everything at 8:30.
Okay. All right, so we're on the record in docket 23-00281. That is People of the State of Michigan versus Thomas Eve. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Kennedy, who is present by the Zoom application.
And sir, you are, and you'll have to unmute Thomas Eve. Mr. Eve, you'll have to unmute.
Yeah, right there. Got it.
Tom Sinevi here.
All right, thank you. This is time set for final pretrial in the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. The people have recently become in receipt of some new discovery in this matter that we have not had time to process over to the defense or take a good look at ourselves. So I believe this is going to be a request for another final pretrial.
No.
So this is based on new discovery. I see Mr. Schaefer's here on the Senate Eve case.
And Ms. Lund.
So this is a new discovery, adjournment for new discovery purposes. Is that a fair statement, Ms. Wicks?
That is my understanding.
All right. And we'll reset for final pretrial then. Do you want to use that jury trial date as the same?
I think that's what we were talking about.
All right. So we'll use that July 8th, 2024 date. That's in what time? 8:30. All right. So use a final pretrial date for July 8th, 2024 at 8:30. And then we'll wait to see the corresponding jury trial date based on what happens there. Does that work, Ms. Wilson?
That works, Your Honor. And I would just request that my witnesses be excused from appearing there. I've had very good contact with both of them and they are both here today.
Ms. Wicks.
No objections as long as Mr. Eve can continue to appear over Zoom as he does have physical limitations.
All right. So the witnesses in the case are will not be subpoenaed for the July 8th final pretrial. You may come anyway, but make sure you keep in contact with the attorney on the case, the assistant prosecutor, Ms. Wilson. But you're not required to be here. And then Mr. Eve, you can also appear via Zoom for that final pretrial on July 8th, 2024 at 8:30. Anything else for the record in docket 23-00281, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Mr. Eve, we'll see you on July 8th at 8:30. Thank you for your appearance today.
Thank you.
Daniel and Dana, you guys can both log off. Thank you for coming, and I'll let you know what we're going to do next later, okay?
Thank you.
Okay, thank you.
Thank you.
Oh, sorry.
Who's next, Ms. Wilson? Johnson, Rodriguez, and
We're setting Rodriguez.
Okay, Rodriguez.
Rodriguez.
Okay.
Makes it correct.
Yeah.
You need to leave.
Mr. Eve, you're all set.
Thank you.
So we're on the record in docket 24-01480. That is People of the State of Michigan versus Alfredo Rodriguez. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Rodriguez, who's present standing to my right.
And sir, you are Alfredo Rodriguez, is that correct? Thank you. This is the time set for a pretrial in the matter, final pretrial. Ms. Wicks, how are we proceeding?
Thank you, Your Honor. At this time, we would leave this matter or have it set for a jury trial. I believe we have a corresponding jury trial date.
All right, so we have leave on for jury trial.
Can't remember if this is one of the ones that got set for a non-trial date.
That's what I feel like.
Yeah.
July 8th, I don't know.
It is, okay.
Okay.
That is the correct date.
Okay.
All right,
Okay.
so July 8th I'm glad you caught that because I caught that too, but I didn't say anything. So we have some out there that are
Yeah, Ms. Holden's caught him.
Yeah,
Yes.
Ms. Holden's catching the dates. All right. So this is set for jury trial on July 8th at 8 a.m. Corresponding jury instructions will be the week before that. Anything else for the record? 24-01480, Ms. Wilson.
Not for the people.
Ms. Wicks.
No, thank you.
All right, Mr. Rodriguez, we'll see you on July 8th. Thank you for your appearance.
Sherry and Jordan, you guys can both log off. I'll be in touch with you a little bit later this week, okay?
Okay. Thank you. Oh, get out of it.
And Mr. Williams, you're here on Mr. Whitaker, who's just appeared. Did you need to meet with him in a breakout room?
No, Judge. James Whitaker and I spoke last night. We're prepared to move
All right,
forward.
perfect. All right, so we're on the record in docket 24-01735. That is People of the State of Michigan versus James Whitaker. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Williams.
Richard Williams on behalf of Mr. Whitaker, Your Honor.
And sir, you could unmute. Your name is James Whitaker, is that correct?
Yes, sir.
All right, thank you. You can hear me all right, Mr. Whitaker?
Yep.
All right, thank you. This time set for a pretrial in the matter Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this out for final pretrial and corresponding jury trial. Additionally, I have received a phone call from Mr. Williams on Friday requesting a bond modification to allow Mr. Whitaker to move out of state for a job. I have spoken with the victim in this matter, and he has no issues with it, so I believe it's the court's discretion.
All right. We'll set for final pretrial on
July 8th at 8:30.
July 8th at 8:30. Corresponding jury trial,
August 5th.
August 5th at 8. And is that a correct statement, Mr. Williams? You're requesting a bond modification for Mr. Whitaker to be out of state. Is he going to be living out of state or work?
That was my understanding.
Mr. Williams.
Yeah, thanks very much, Your Honor. This man recently graduated from high school, a good student. He has no prior record, and he's a fellow by the name of Jackson Julson, Julson. His name is Matthew Julson. Phone number 641-390-0920. He is a higher up in a place called Inver Energy Corporation. It's in Burnt Tree Township, Illinois. I have the address and his other information, but he said that he needs someone of James's caliber to become a journeyman solar electrician, and he's willing to take him there and proctor him until he receives that credential. And in my opinion, these things don't happen overnight. So he must have stood out in many things. I will take responsibility for his behavior while he's gone. I will do it personally. I don't usually do such things, but given the facts that I believe in this, I asked the court to modify the bond. And the second issue that I'm here today on, and it's a minor one in my opinion, but major in many cases, is that on the 19th of June, I sent out a request to get a police report, so at least I get another person's view as to what type of thing took place between Mr. Whitaker and his brother Chase. Some wrestling match, evidently, that the reason why we're here. And so my point is that I just like to see a police report so I'm able to better understand some other point of view other than James's.
Right. So Mr. Williams will you'll provide Ms. Wilson with the updated address, and then you can apply. So just for pretrial services, is that fair, Ms. Wilson?
Yes, that's fair. And it does look like we sent out discovery on the 20th.
All right.
If it's not in receipt by now, it's possible it was to the wrong email. So I'll look into it.
Okay.
Yep.
So the discovery information will be looked into. And then Mr. Williams, if you sent to Ms. Wilson the updated address, we'll make sure pretrial services has all that information. Okay.
Well, I'll tell you what, all of the information, including everything about his employers, stats, where he'll be, the prosecutor as well as the court system gets this. So I'll prepare a stipulation and send it over and see if it passes muster with Ms. Wilson. And then from there, it'll go on to whatever court agency you wish.
That's fine. Yeah, that works. Just as long as pretrial services get an updated address or contact information. I'll modify the bond to allow for out-of-state travel pursuant to this case. And then Ms. Wilson's going to be looking into the discovery. Anything else for the record in docket 2401-735, Ms. Wilson?
Not for the people.
Mr. Williams.
Just a pleasure to meet Ms. Wilson for the first time. I'm hoping to steer her into the future. Thanks.
Thank you, Mr. Williams. It's good to see you too. All right, Mr. Whitaker, you're all set. Thank you for your appearance today.
Thank you.
All right. Thanks, Ryan. Bye-bye.
Bye-bye. for on the record in docket 24-01215. That is people of the state of Michigan versus David Word. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Wicks. Ms.
Taylor
Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Word, who is present and standing to my right.
And sir, you are David Lee Word, is that correct? Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter was subpoenaed. She is not here today. We have not been able to make contact with her. However, I do believe I could proceed without her if I had the opportunity to subpoena a foundation witness for some videos. So I would be requesting another final pretrial. Additionally, there is a possible global resolution in play here with the felony file that's currently up in 30th Circuit. So I would just request another final pretrial.
All right. And there's a PR bond on this, is that correct, Ms. Wicks?
I believe so, Your Honor, but I would argue that Mr. Word does have confrontation rights under Crawford and the 14th Amendment to the United States without a complaining witness, even with a video and establishing foundation. Mr. Word still has the right to confront his accusers. And without the complaining witness here, the defense would be asking this case to be dismissed.
All right. Well, I will allow, this is the first request. This was set for final pretrial on June 6th. The defendant is PR bonded on this file. So I will allow one adjournment in this matter. And then this is a trial matter, so this is for trial. So Ms. Wicks, if you have any confrontation issues that you see may be at issue here, let's brief them. Yeah, let's brief them, because this, of course, isn't a bind over on the prelim.
Yes.
This is the trial, and I believe that my reading of it is that if they can lay foundation for the video, they can use the video, but that doesn't mean that the victim will be here. But that doesn't mean that Ms. Wicks gets to cross-examine anybody who's laying foundation for the video itself. So it does raise some confrontation issues. There's no doubt. So I will entertain any motions to be brought on that, and we'll allow for one adjournment. We'll reset it for pretrial to give everybody some time. And what date do you want to use for final?
Do we have a jury trial date set?
We don't. So we kind of, so I imagine we do the final pretrial and we'll set a final pretrial and jury trial.
Yeah.
Do you want the final pretrial 1 more week out?
Yes.
Yes.
Okay, so let's do the final pretrial. July 15th at 8:30.
Okay. July 15th at 8:30.
And the trial August 5th.
Trial will be August 5th at 8 o'clock. All right, so we set the final pretrial July 15th at 8:30, trial at August 8th at 8 o'clock. Anything else for the record in 24-01215, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Mr. Word, we'll see you on that July 15th date, and then we'll go from there. Okay, sir? Thank you. Yeah.
Make sure you get it. Is the phone still good for you? Okay. I'll do
Laura, are you ready on Humphrey? Want to go?
No, let me correct it. Sorry, I'm getting
No,
updated
you're
contact
good.
info for Mr. Word.
We, just for notification purposes, we have Ms. Dane,
This is Ms. Wicks.
Ms. Nealon.
Choose mine, Your Honor.
All right. Do you need to meet with her?
I will briefly, Your Honor. I think we're going to go with Mr. Humphrey and then I can meet with
All
him.
right. Let's go on Mr. Humphrey and then let me know.
Thank you.
How are you, Ms. Sutter?
I'm well, Your Honor. How are you?
Right, so we're on the record in docket 24-01417, 18, and 19. Will the parties please introduce themselves for the record? Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Humphrey, who's standing to my right.
Ms. Wilson.
Abigail Wilson for the people.
And sir, you are Richard Humphrey, is that correct? Yes, sir. All right, thank you. This is time set for a pretrial in the matter. Ms. Wilson, how we proceed?
I would defer.
Ms. Sutter.
Thank you, Your Honor. There's a couple of things going on here. Mr. Humphrey is seeking to gain compliance. We also are still awaiting discovery in this case. Given those two things, I would request an adjournment here, perhaps 6 to 8 weeks.
Okay. So we have, and Ms. Wilson, is there any objection to the adjournment? This is
No.
the first request, I think.
I have no objection, Your Honor, and I do see that it looks like discovery hasn't been sent out, so that's correct, and I'll inform our discovery unit of that as well.
All right, and then Ms. Sutter, I have the arraignment that Mr. Humphrey at least was looking at moving to West Virginia. I don't know if that's still the case.
Yes.
But of course, he should update any information with us on these dog cases.
Correct, Your Honor. He is still planning on that move, I believe, after next week, and we will be updating the court
All right.
address as soon as we have it.
All right, so let's adjourn for discovery and compliance. 6 to 8 weeks. August 5th at 9 o'clock. So we'll adjourn for discovery and compliance to August 5th at 9 o'clock. Anything else for the record in docket, in any one of these dockets, 24-014-17, 18, and 19, Ms. Wilson?
Not for the people.
Ms. Sutter.
Nothing further. Thank you.
All right, Mr. Humphrey, please keep in contact with your attorney, Ms. Sutter, and update her with any new information you have. You're all set, sir.
Is it okay if I grab this? Is it okay if I take this?
There's gonna be a total of 3 from him. Yes, thank you. I'm sorry.
Oh, okay.
We can't group schedule like we used to. And
That's fair. Just kind of check before I started grabbing things.
I appreciate it. I forgot that shot was in there. I'm sorry.
It's okay.
Here's his last time.
So, Ms. Sutter, did you need to meet with
Yes, Your Honor. I'll log in to see if I can meet with Ms. Nailon briefly.
Nayland? All right, Ms. Nayland, I'm going to put you in room 1 with your public defender, Ms. Sutter. So you should get a prompt to go to room 1. All right, ma'am?
All right, thank you.
Taylor said that there was already a conflict. Matt Samuel's already accepted it.
Right. I know.
How are you, Sean?
Good, Your Honor, yourself.
Pretty good.
Do you want to go on it?
Yes.
Okay.
Your Honor, if I may, I apologize. I forgot. I already know what I'm supposed to do with Ms. Nailon. We are ready to go on her action.
All right, let me move her back.
Yeah.
If it's easier, I can pop into the breakout room and tell her to leave.
No, she's right. She's back with us now.
Okay.
Ms. Nayland, we're able to put your case on the record.
All right.
All right. So we're on the record in docket 24-01602. That is City of Lansing versus Nia Nayland. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing for today's hearing only on behalf of Ms. Nailon, who's joining us via Zoom.
All right. And ma'am, you are Nia Nayland, is that correct?
Yes.
And you can hear me all right, Ms. Nayland?
Yes.
All right, this is the time set for pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe the conflict counsel is coming into this case. I will defer to Ms. Sutter.
All right, Ms. Sutter.
That's correct, Your Honor. I represent a conflict of interest in this case, given that my office has sought conflict counsel. That is Matt Samuels. He'll be taking over the case from here on out. His schedule just did not allow his appearance today. I would request an appearance on his behalf so that he can communicate with Ms. Nalon and get the discovery.
All right. And that's your understanding, Ms. Nalon, you'll be receiving conflict counsel, Matt Samuels, and so we'll adjourn this and reset it so you can talk to Mr. Samuels?
Correct.
All right. Let's adjourn this pretrial for conflict counsel. At least a couple of weeks, don't you think?
At least,
At
yes.
least.
July 15th at night.
All right. We'll set it for July 15th at 9 a.m. For conflict counsel, Mr. Samuels to meet with Ms. Nalon. Anything else for the record in 2401-01602, Ms. Wilson?
Not for the people.
Ms. Sutter?
Nothing further.
All right, we've set this July 15th at 9 o'clock. And Mr. Samuels have the opportunity to meet with you before that pretrial. All right, ma'am?
All right. Thank you.
You're all set. Thank you, Ms. Nalon.
All right.
And then Travis Arnett Blaine is here in the courtroom. He is unrepresented.
All right. Oh, he was denied. What date?
And 6:14.
All right, Mr. Arnett Brain, why don't you come up here? So we're on the record in docket 23-02489. That is people of the state of Michigan versus Travis Arnett Brain. Will the parties please introduce themselves for the record, Ms. Wilson?
Abigail Wilson for the people.
And sir, you are Travis Arnett Brain, is that correct?
Yes,
Thank you. And you are unrepresented by counsel today, is that correct?
yes,
All right. And my records would indicate that Mr. Arnett Brain was denied public defender status on June 14th. Is that fair?
I have no reason to doubt
All
that.
right.
June 10th, but yes.
Oh, June 10th. Mr. Arnett Brain, would you like the opportunity to speak with the assistant prosecutor on this case for this pretrial?
sure.
Okay, yeah, it's up to you. I think Ms. Wilson would be willing to talk to you, but I want to make it sure on the record that it's your choice to meet with her to discuss this case. This is a pretrial, and we either work it out or we set it for final pretrial and jury trial. Generally, in this case, since you are not represented today, I'm gonna explain the whole process to you. So, do you have a preference as to how you'd like to proceed today?
Like not give you a guilty.
You don't have to indicate any of that. You can meet with Ms. Wilson, or we can just set it for final pretrial and jury trial.
Yeah, can I meet with her?
Sure.
Is he planning on getting an attorney?
Mr. Arnett, Brain, are you planning on getting an attorney?
I don't even have no reason to know why I'm denied for one. They called me, told me I had 48 hours to call her back. I called her back, couldn't leave no message. It just kept ringing and ringing and ringing.
All right. And so
Do you see a reason why there was a denial of
Yeah.
the system?
it might be in their computer system as to, I'm assuming it's because you make too much money.
Huh?
Lawrence,
Oh,
look at it.
okay.
So.
They don't do that.
Yes.
So, Mr. Arnett, Brain, did you plan on reapplying because of change of financial condition? Or are you gonna go forward on your own, or are you gonna retain your own lawyer?
Can I try to reapply?
You can, yeah, you can, and what we'll do is, I'm gonna set this for a second pretrial today. And on your notice, we'll make sure that the public defender's number is written on there, okay? So you can, and I can write it on there if it's not already on there. So D to reapply to public defender's office. Because there may be a change in the financial status, and we'll reset the prelim, we'll reset the pretrial for July 15th at 9 a.m. The phone number is 517-679-2979. So if you call that number to make the reapplication to get that process going, this letter might be able to help you with that. I'm uncertain, but it's on the notice too that we're going to print out for you. Okay.
Yes.
All right. Anything else for the record in 2302-489, Ms. Wilson?
Nothing for the people.
Mr. Arnett, Brain, do you have any questions of me?
No, sir.
All right. My court officer will give you the notice, and that should have the July 15th date on it. All right, sir?
Yes, sir.
All right. Thank you. Dan Summer just joined us. That was Mr. Brain Autry.
Is Autry here?
All right, so we're on the record in docket 24-01095. That is People of the State of Michigan versus Johnny Beasley. Will the parties please introduce themselves for the record? Miss Wilson.
Abigail Wilson for the people.
And sir, you are Johnny Beasley, is that correct?
Sir.
And you are unrepresented by counsel today, is that correct?
Sir.
Right, this is the time set for pretrial today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. At the last hearing, I did provide Mr. Beasley with an appearance. It's my understanding that one hasn't been received by the court yet, so discovery still has not been out yet. So not sure what the court wants to do here.
We've got, so, Mr. Beasley, did you file an appearance to get discovery?
Yes, sir.
With our criminal court?
Yes, sir.
I don't show it. Can I see it, please?
Yes. I'm trying to track down an appearance on your behalf. There should be like a generic.
I don't show it, and I don't have it in file, so I don't know what happened.
That's something we can print out. Yeah. See if we can. So Mr. Beasley, what we're gonna do is we're gonna see if we can print one out, have you sign it. You're not gonna get discovery till you get an appearance on your own, all right? And then we're gonna have you go in and file the appearance, all right? So we get it all done, so we'll get it done today. And then Ms. Wilson will be able, once you have an appearance, we'll be able to send discovery to whatever, wherever you put it down. But, and then we can reset the pretrial, but we want to get this appearance thing taken care of today. That's just a criminal, right? The window? That's not a definitive yes.
Yes.
All right, so Mr. Beasley, let me take a look at that, Sean, just before. Thank you.
Oh, I printed
Is that the ROA?
No, it's a separate case.
Oh, it's a separate case? Yeah,
I'm printing this.
yeah. Because you'll have to take it up there all filled out. But we may fill it out on the record here.
I did that.
Oh, did you?
That's
That,
why we-
okay, let me see it, but you may have to do is sign this. So I'm holding in possession of 24011095. That's an appearance for Johnny Beasley. You're appearing on behalf of yourself. I don't have to sign this, right?
Nope.
So at the bottom of this, there'll be a date and a signature line for you. And then you should put in your name and your address and zip code. And then take this to the window, all right? And once all that filing is done, come back and we'll put you back on the record in regards to your pretrial, all right? That way we get the discovery stuff all done.
Sean, could you put your email somewhere on it too? That's how our discovery will send it out.
Yeah. And my court officer will walk you over to the window.
I just wanted to get every copy.
Yes. That's a really good idea. Yeah, they probably will. They want at the window, will they? They might, but let them know. I'll tell them. So, Mr. Beasley, it appears that there may be an open alcohol ticket out. Is that a warrant?
Yes,
Yeah, he
sir.
failed to appear for the pretrial.
Yeah, so you might have to see the magistrate while you're out,
Okay.
after you're done here,
All right,
in regards to the open alcohol ticket.
all right.
But- Clear stuff.
Yeah. I'll show you.
The magistrate. Yes, yeah, that's exactly right.
Starting going back.
Let's fix this.
because I was-
Or else we'll be here next time. and yes. So Miss Wicks and Miss Sutter, Julia Dane,
I believe I'm on everybody else.
Are you?
This morning.
Alicia Cedeno, and William Van Sumeren.
I mean, Sumerum does not have.
Yes.
All right.
He declined us.
All right.
You
So
didn't
are
say
you
I'm not
ready
here,
on
honey?
Miss Cedeno? No, you're here. Let's get you want to go on, Miss Cedeno? We can hear everything you're saying, Miss Cedeno. That's why I said that. All right.
I'm sorry.
You're all right. All right, Mr. Cedeno, we're going to call your case. So we're on the record in docket 20-3250. That is People of the State of Michigan versus Militia Cedeno. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Sedino.
And ma'am, you are Militia Cedeno, is that correct?
Yes.
And you can hear me all right, Ms.
Yes, Your
Cedeno?
Honor.
Thank you. This is the time
Yes, Your
set for
Honor.
pretrial in the matter.
Yes.
Ms. Wilson, how are we proceeding?
I think this is gonna be a request for final pretrial and corresponding jury trial.
And that's a fair statement, Ms. Wicks?
It is.
It will set for final pretrial on July 8th at 8:30. And the corresponding jury trial on
August 5th.
August 5th at 8. So we've set the final pretrial on July 8th at 8:30. Jury trial set on August 5th at 9 o'clock. Your notice will be sent to the notice you gave at arraignment, which was the Gordon Avenue address. Is that still a good address for you, Mr. Daniel?
Yes.
All right. Anything else for the record in docket 20-3250, Ms. Wilson?
Half of the people.
Ms. Wicks?
No, thank you.
All right. You should be all set, Mr. Daniel. Thank you for your appearance today.
Thank you.
All right. And then, so we're back on the record in docket 24-01095, and I have an appearance in the court file for Mr. Beasley. Do you want a copy of this?
Yes, please.
Yeah. So let's make a copy so we can get a jump start on the, there you go, Sean. Thank you. We'll get a jump start on and we'll reset this for pretrial. I'll indicate the discovery, the appearance has been filed. And prosecutor was given a copy. So we'll reset for pretrial for discovery purposes. On July 8th at 9 o'clock. And you should get notification from my court officer. We'll print out July 8th at 9 o'clock. Anything else for the record in 24-01095, Ms. Wilson?
Half of the people.
Mr. Beasley. Yes, sir. Do you have any questions of me? Yes, sir. All right. You should be all set. And then I think the magistrate is going to clear up the warrant, or
He's gonna come back.
I'm gonna come back in the
this
morning.
week. That-
I'm gonna come back
all right.
tomorrow morning
Now.
to do it.
Okay,
Like in the
perfect.
morning.
Thank you.
Thank you.
I don't have anything yet. I gotta think about that one.
That's when there's a discrepancy on judge.
Nope, it's fixed.
It's fixed.
Is it fixed? Okay. So we're on the record at docket 24-01557. That is people of the state of Michigan versus Julia Dane. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Dane.
And ma'am, you are Julia Dane, is that correct?
Yes.
And you can hear me all right, Ms. Dane?
Yep.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a request for an adjournment for another pretrial to discuss possible negotiations.
That is correct, Your Honor.
Thank you, Ms. Wicks. So request for adjournment for negotiations to continue. And we'll reset for
July 8th at 9.
July 8th at 9 o'clock. So Ms. Dane, we've reset this for negotiations to continue between Ms. Wicks and Ms. Wilson. And you'll get notification sent to your last known address, that Lincoln Avenue address. Is that still a good address for you, ma'am? All right.
Yep.
Anything else for the record in 24-01557, Ms. Wilson?
Not for the people.
Ms. Wicks.
No, thank you.
All right. You're all set, ma'am. Thank you for your appearance today. Mr. Ben Sumerin. All right, Mr. Van Sumeren, we'll call your case. So we're on the record in docket 24011462 and 24011463. That is people of the state of Michigan versus William Van Sumeren. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Sir, you'll have to unmute. You are William Van Sumeren.
Have to speak. Yes, sir. William Van Summer.
Right.
That's me.
All right. And you can hear me all right, Mr. Van Sumeren?
Yes, I can.
All right. Thank you. This is the time set for a pretrial in the matter. Mr. Van Sumeren, you are not represented by counsel. Is that correct today?
That's correct.
All right. Ms. Williams, did you want the opportunity, or did you want to offer Ms. Van Sumeren the opportunity to speak to you before we get started? Did you want to just place it on the record?
I'll just place it on the record.
All right.
At this point, I'm requesting another final pretrial. As far as discovery, all I have is the ticket. So I have no idea what happened here. So I'm not really prepared to make any offers until I have some inkling of what's going on.
All right. Mr. Van Sumeren, the assistant prosecutor only has the ticket to work from, and so is requesting that they be able to talk to the officer in the matter. At least the looks like it's written by DNR.
Yeah.
I have not seen a DNR ticket in
Lansing, no.
in
I'm
Lansing
shocked,
in
yes.
years. So we'll reset or adjourn the matter to give the APA some chance to talk to the DNR officer. If this fits into a compliance matter, we can go from there. And Mr. Van Sumeren, this probably helps you in regards to eventually meeting with the APA just to show some compliance purposes, if that's the issue. If not, that'll give the APA some chance to get more information about the ticket, because it's written on a ticket. Does that make sense to you, Mr. Van Sumeren?
Yeah, I understand.
All right. Do you have any questions of me on this? I know this looks like a no fishing license and a catch limit ticket.
Right.
But yeah, we'll let the APA do some more investigation, and we'll just reset it for pretrial. All right.
All right.
We'll reset for pretrial. Reset for pretrial on July 15th at 8:30 at 9. July 15th at 9 o'clock. And Mr. Van Sumeren, you should be fine attending by Zoom as you are today, okay?
All right, Your Honor, I don't understand something. I don't understand why it's such a process to take care of this.
Well, it's because it's a misdemeanor case, and so it's not like a speeding ticket. We have to treat it like any other misdemeanor, where the potential is any type of incarceration, but it's written on a ticket, which is unusual for a misdemeanor. A, B, we don't see a lot of DNR violations out of the city. At least I have not probably seen one in 25 years or so. That's why it's being treated a little differently. But it does kind of work in your favor to have a little bit more information, because all we have to go right now is on a ticket. So we got to treat it like a drunk driving. And this is much different than a drunk driving.
But why? I do. Can I ask a couple of questions here?
You can ask on the process. Don't share any of the facts, because
no,
you're on the record. You're on the record.
Okay. What I want to know is I was fishing without a license, okay, and
yeah. So you don't. So let's not get, because you're on the record, and we don't want to say anything that might. I have to treat this like, because it's written on a ticket. I guess the best example would be like a drunk driving, because the statute has the potential for incarceration in it. And but as we both can see, this is a fishing ticket, but I've got to treat it as though it's misdemeanor. So let's get more information to the APA And
Okay.
then talk
All
to
right.
her, but don't make any admissions on just, that's the safest play right now.
All right.
All right.
Okay.
I've
That's
reset
what I
it for
don't
July 5th.
understand.
Right, I understand. I understand. It is written from a statute that requires the potential for incarceration. And so
All right.
that's why we have to treat it like, like you would, like that, because that's the way the statute's written. All right. You'll get notice sent to your last known address on Climax Street. Is that still a good address for you, sir?
Yes, it is.
All right. Anything else for the record in 24014662 or 63, Ms. Wilson?
Not for the people.
All right, Mr. Summerin, you're all set, and I'll see you on July 15th. All right, sir?
Thank you.
Thank you.
Hi, good morning. All right, I sure will.
Hello?
Yes. Hello?
Are you talking to me? Hello, are you talking to me, ma'am?
On the Samsung, would you please identify yourself, please? Sir, your name?
I believe that's Michael Cole.
Michael Cole.
Are you Michael Cole, sir?
Yes, sir. Can you hear me?
Kind of. I can kind of hear you. You're moving around a lot, but you are Michael Scott Cole. Is that correct?
Yes, sir.
All right. Stand by. You're in the right place. I can hear you. We'll call your case in just a second. All right.
Thank you very much, sir.
All right. So, Ms. Chapman, we'll call your case. We're on the record in docket 24-00672 and 673. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Chapman, who is
And-
present via the Zoom application.
Thank you. And ma'am, you are Ebony Chapman, is that correct?
Yes, I am.
All right, and you can hear me all right, Ms. Chapman?
Yes, I can. I can hear you very good.
All right, thank you. This is the time set for pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a request for a final pretrial and corresponding jury trial.
That is correct, Your Honor.
All right, thank you. We'll set for final pretrial on
July 8th at 8:30.
July 8th at 8:30. And corresponding jury trial.
August 5th.
Fifth at 8. So Ms. Chapman, you'll receive notification of the final pretrial on July 8th at 8:30 and jury trial on August 5th at 8 o'clock. And that'll be sent to the Magnolia Avenue address. Anything else for the record in dockets 24-00672 or 73, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Ms. Chapman, you're all set. Thank you for your appearance today.
Thank you.
Miss Kara Kemp Torrey Blackman. What case are you here on, ma'am? Still not connected on here.
Eviction, right? Judgment. Global Park. What is wrong?
We're here.
Ma'am, what are you here on? Miss Kara Kemp Torrey Blackman?
We're here on behalf of the Grove Apartments. We're here for a judgment summons that we had.
And it says today, it says Monday, June 24th on your notice.
Oh, I'm so sorry. It actually said July.
Yeah, I think you're a full month early.
I'm sorry.
It's all right. I'm just glad you're here, okay?
Okay.
But you're not due in court till probably, I would assume it's next Wednesday, it's July 24th,
July
Wednesday.
24th.
Yeah, because July,
Oh.
Wednesday is landlord tenant day. So that would be July 24th, Wednesday. All right, ma'am?
Okay, thank you. I appreciate you
welcome.
guys.
Yeah,
Sorry.
no worries. All right, Mr. Cole, we'll call your case. So we're on the record in docket 2401203. That is people of the state of Michigan versus Michael Cole. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Cole.
And sir, you are Michael Cole, is that correct?
I am, Your Honor. Yes, sir.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this set it for final pretrial and corresponding jury trial.
That is correct.
Okay. So we'll set for final pretrial on
July 8th at 8:30.
July 8th at 8:30. And jury trial set for
August. All right, 8.
August 5th at 8 o'clock. So we've set the final pretrial for July 8th at 8:30. Jury trial is set for August 5th at 8 o'clock. Mr. Cole, you'll receive notice at the Mason address on Karam. Is that still a good address for you?
Yes, sir. It is 912 Karam
All
Circle.
right, thank you. Anything else for the record in 24-01203, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Mr. Cole, you're all set. We'll see you on July 8th at 8:30.
Thank you. You guys have a great day.
You too. All right. Ms. Hill, we'll call your case. Can you hear me all right, ma'am? All right, you'll have to speak up because you're a little further away from the microphone, all right? All right. So we're on the record in docket 24-00524. That is people of the state of Michigan versus Alyssa Hill. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Hill.
And ma'am, you are Alyssa K. Hill, is that correct?
Yes.
And you can hear me all right, Ms. Hill?
Yes.
Thank you. This is the time set for I have it kind of as a motion, but I don't know if that's, yeah, Ms. Wilson, how are we proceeding?
I believe this is Ms. Wick's motion, so I will leave it to her.
All right, Ms. Wicks.
Thank you, Your Honor. At this time, Ms. Hill is currently on a remand-only bond. I understand she does have one prior failure to appear, but Your Honor, one prior failure to appear should not subject her to a continuous remand-only bond in a case. As evidenced by my motion, she does have a place here in the jurisdiction. She can live with her stepfather, who does have a steady address here in the area and a phone number. She would resume seeking her employment. She does have a young child. She would be willing to wear a GPS tether, so that she does not either miss or avoid any other court dates. But Your Honor, what I'm truly asking you to do is lift the remand only and just set a bond in this case. If the court is willing to go to some sort of personal recognizance bond with a tether, that is what we are ultimately asking. But with the prior failure to appear, I understand if some sort of 10% bond is put in place.
Right. I'm looking at that because this is a different case. It came out of the magistrate on May 2nd as a remand, which is, and then I signed on May 20th, another remand. So she was remanded on May 2nd. That must have been I don't know why the magistrate, oh, she was rearranged on May 2nd.
Correct.
That was after the fail to appear.
Yes.
And then on June 6th, she had a pretrial and she had medical verification. Does that sound right? June 6th, and we set it for global resolution on July 8th. Does it sound right?
Correct.
Okay. I have adjourned global resolution July 8th, and that might be set for jury trial. All right, is there a jury selection on another file out there?
It sounds like on in her 55th case, there's a jury selection set for today. It looks like her bond in that is 2,500. I can't tell if it's 10% or not.
All right,
And the jail is just showing this as bond denied. It's not showing what the 55th case is, so I'm not entirely sure what 55th is doing.
According to our notes, Your Honor, if it does make a difference to the court, it is a cash surety 2,500. But I do not know if that has been lifted or changed as of this morning, as she did have a court date out there this morning.
all right, and then I see that bond was initially set at $1,000, 10% on this case, and then it was remanded.
I believe
Does
so.
that sound right? All right, Ms. Wilson, response to the motion to set a bond because she's on remand status.
Thank you, Your Honor. I agree that I think remand is a bit much here. This is defrauding an innkeeper. It's not a violent offense. But given the failure to appear previously in this case and in the 55th case, I think some kind of 10% or something should be appropriate here.
Right. I agree. We lost track of Ms. Kill a little bit, and then I know there's a couple files out there, but I will modify bond to be set at $2,010%, and then with GPS monitoring. Since there's a fail to appear, and this is not the only file on the case. So I'll modify bond to be set at 2,010% with GPS monitoring. Anything else for the record in 2400524, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Ms. Hill, we've modified your bond to the 2,010% with the GPS monitor. That'll be notification purposes. Because I don't think we're doing, how do they want me to write that?
Just GPS for monitoring.
GPS for monitoring.
No zone or big.
We're supposed to be specific, but I change it every time I write it. So I don't know if that works or not. All right, so it is for GPS for monitoring purposes. That's all for the record. And go ahead.
Her trial is scheduled for July
8th.
8th.
Okay. All right. And ma'am, you do have a trial set for July 8th at 8 o'clock in this court. So that's all for the record in 2400524. Thank you for your appearance today.
Thank you.
Thank you. All right, so we're on the record in docket 2400280. That is people of the state of Michigan versus Joseph Johnson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Johnson, who does not appear present this morning.
All right, this is the time set for a regular pretrial in the matter. This was scheduled for 8:30. It's now 10:04. It would appear that the defendant I do not see Mr. Johnson in the Zoom courtroom, physical courtroom, or the Zoom courtroom. It would appear that Mr. Johnson has failed to appear for pretrial. Ms. Wilson, how would you like to proceed?
Thank you, Your Honor. I will largely leave it to the court's discretion. This is, I believe, his first ability to appear on this file. It's my understanding that he appeared in front of Judge Simmons on another file last week or a couple weeks ago. I think maybe resetting would be appropriate in this case. It is a dog case.
Ms. Wicks.
Thank you, Your Honor. I would also be asking for a courtesy reset in this case. He did appear either last Thursday or Friday, I believe, in front of Judge Simmons. I also know that our office was, he did hire an attorney. I do not know if he's in the process of hiring an attorney on this case, and that may be some sort of confusion. But I cannot explain his non-appearance here today. But I would appreciate a courtesy reset.
All right, we'll reset for pretrial. There's a couple things going on. It's an unlicensed dog case. We'll reset for pretrial on July 8th at 9:30? At 9. All right, we reset this for July 8th at 9 o'clock. Anything else for the record in 24-00280, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
Thank you. And Mr. Autry. That's a dog case. All right, so we're on the record in docket 24-01081 and 82. That is People of the State of Michigan versus Maurice Autry. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Autry, who does not appear present this morning.
Right, we set this for 9. This was set for pre-trial for 9 o'clock. It is now 10:07. It would appear that the defendants failed to appear for the pretrial. I do not see Mr. Autry in the Zoom courtroom, physical courtroom, or waiting room. And based on the representations of counsel, it would appear the defendants failed to appear for pretrial. Ms. Wilson, how did you want to proceed?
Thank you, Your Honor. I believe this is Mr. Autry's first failure to appear. This is a dog case, so I believe it's the court's discretion.
Ms. Wicks.
Thank you, Your Honor. I would be asking for a courtesy reset if the court is so inclined in this case. If they are not, I would be asking for a 48-hour hold.
Let's see. He's been arraigned twice on this. I have April 12th arraignment and then June 10th arraignment.
Yeah, our office was not involved in the case until the June 10th.
Let's issue a bench warrant and bond forfeiture with a 48-hour hold. And then let us know if you hear from Mr. Autry. This is also a unlicensed dog case.
Yes.
All right, so that's all for the record in 24-01081 and 82. Then let's go on Mr. Charles. So we're on the record in docket 24-01119. That's People of the State of Michigan versus Prophet Charles. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Charles, who does not appear present today. I know he was just in front of, I believe, also Judge Simmons last week.
I think he was in front of, well,
Was it
2
you?
weeks ago, he was in front of us.
He was also in front of you for a PCC last
Yeah.
week.
Okay.
Oh, was he?
Yes.
I thought it was one for
All right.
the judge. Nope, that is
No,
not.
he's got a Simmons and Flores.
All right. So this is the time set for a pretrial on a driving no ops. This is set for 9:30. It is now 10:09. It would appear that Mr. Charles is not present. He's not in the Zoom courtroom, physical courtroom, or waiting room. Here, the defendants failed to appear for pretrial. Ms. Wilson, how did you want to proceed?
Thank you, Your Honor. This is Mr. Charles' first fail to appear. However, he has several cases going right now, and I'm a little concerned about his non-appearance today. He is supposed to be in front of the court on Thursday or Friday this week on a felony file. If he's not there on that case, I would definitely be asking for a bench warrant. Perhaps we wait on a bench warrant on this file until that prelim date.
When is the prelim set for this?
It
week?
is-
Thursday or Friday?
Yeah, 6/27 at 8:30. And Your Honor, that would be my ask, is that
Alright.
this file just get held more a 72-hour hold, I suppose, than a 48-hour hold.
So I'm gonna indicate D has a prelim on June 27th. What time is that? 8:30?
Yes.
8:30. So we'll hold bench warrant until prelim to see if he. And so we'll just keep this with the prelim
Thank you.
file. Anything else on the record in 24011119, Ms. Wilson?
Not for the people.
Ms. Wilson,
No, thank you.
thank you. And then there's Mr. Williams. Well, I think he's got a case coming up.
I thought we did.
I thought we did too.
Yeah.
Yeah. Because we told him that was part of the don't
Bill,
press like
no,
that.
mhm.
Yeah. So on the record in 24000548, people of the state of Michigan versus Michael Williams. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Williams, who does not appear present this morning.
Yeah, this is the time set for a pretrial in the matter. It was, it was set for 9:30. It's now 10:12. It would appear that the defendant has failed to appear for the pretrial. I do not see Mr. Williams in the Zoom courtroom, physical courtroom, or waiting room. Mr. Williams, I did see him last week, if I remember correctly. We had some discussions about him being at least attending by Zoom and being appropriate by Zoom at this hearing. I think Ms. Wilson was by Zoom at that hearing.
I was.
How did you want to proceed, Ms. Wilson?
Thank you, Your Honor. If I'm recalling correctly, I think when we discussed that with him, we were talking about his prelim set for this week. I don't know if we actually brought up his dog ticket for today. He does have a prelim set this week on Thursday. Since this is a dog ticket and he has appeared previously, I think it would be appropriate to hold a bench warrant in abeyance until the prelim.
That is what I'd be asking for.
Thank you, Ms. Wicks.
Thank you.
So we'll hold the bench warrant and bond forfeiture in abeyance until the prelim. And that prelim is set for
Again, this Thursday at
Thursday.
8:30.
June 27th at 8:30. All right, so we'll hold the bench warrant bond forfeiture in abeyance. Since he's to be in front of the court June 27th at 8:30. Anything else for the record in 24000548, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right. That's it. All right, so we're on the record in docket 24-00422. That's People of the State of Michigan versus Ashley Mays. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Mays, who is present and standing to my right.
Ma'am, you are Ashley Mays, is that correct?
Yes.
Thank you. This is the time set for sentencing in the matter. Is there any restitution in the matter, Ms. Wilson?
Thank you, Your Honor. As part of the plea agreement, there was an agreement that the defendant would pay restitution for repairs to Miss Pratt's car. At this time, the people are not in receipt of the information as to the amount. So the people would request that the court order $1 at this time and allow the people to petition within 30 days if they receive new information.
So you have not heard from Ms. Pratt back. So that was indicating in the victim's statement. And there was restitution to be made. So at this time, ordering some restitution, and then if you get any information back, would you set it for restitution hearing?
Yeah.
Ms. Wicks.
Your Honor, I will leave it to the court's discretion. I would just note for the record that both, it sounds like Ms. Wilkinson and probation reached out to Ms. Pratt. She has not responded to either reaching out, but I would ultimately leave this in the court's discretion.
And they both indicated they'd be here today, right?
If I can clarify, Your Honor, I have spoken to Ms. Pratt. The last time I spoke to her was before the last sentencing hearing, in which Ms. Mays had indicated that she was wanting to withdraw her plea. She told me at that time that some life circumstances had gotten in the way and she hadn't been able to get the truck to the body shop or whatever it was in order to get an estimate. Since then, I've attempted to contact her and I did not get a response. She indicated that she was going to get it done. I just have not received the information yet. And as far as them saying they were going to be here, they said they were going to be here at the last hearing. I know Ms. Pratt had work come up, so she wasn't able to be here. I'm not sure about Ms. Burnett, but she is not requesting any restitution on this matter.
All right. With that understanding, we can go forward. And then if you hear anything, you can make your request for a hearing.
Thank you, Your Honor.
Have you had the opportunity to go through the pre-sentence report with Ms. Mays?
I have. We have no additions, deletions, or corrections.
All right, allocution, Ms. Wicks.
Thank you, Your Honor. This case, although I haven't handled it from the beginning, it is my understanding stems from a mother trying to protect her child. It stems from somebody dropping her child off to someplace she doesn't know, where she doesn't know the people, she doesn't know who lives there. And she reacted in a way she's not proud of, but in a way I'm hopeful that Your Honor as a parent could understand that when you find out your young toddler is in a stranger's home with you not knowing anything about where they are, why they're there, the panic that may ensue. And so, Your Honor, she's here to accept responsibility for her actions on that day. I just do ask that you keep that in mind when ultimately sentencing Ms. Mays. I would be asking the court for less than 12 months of probation. She is a single mother, 2 children. The financial hardship that probation is going to place on her, just trying to live in this day and age with multiple children on one person's salary is a lot. To add the court costs and an additional, $360 on top of whatever the court orders and fines and costs, plus whatever restitution is, plus all the classes. So I'm asking for a downward departure to the timing, and that the court put in that if grant funding is available for the MRT programming, which it should be, that the grant be that probation look into the grant for Ms. Mays to help her pay with that so that the money can go towards the children and continuing to live. So ultimately, I'm asking that you more or less follow the recommendation probation other than the amount of time.
All right,
Thank you.
thank you. I don't have an order on this. We have a JOS,
Okay.
but if you
I'll print it.
if you print one out, I will
Right.
write on it and Ms. Mays, is there anything you'd like to say to the court before the court passes sentence?
No, Your Honor.
I've had the opportunity to read the PSI, so I know very little about the defendant's version of this other than the attorney who has spoken, the indication. Ms. Wilson, did you have anything you'd like to say?
I do, Your Honor, and at this time, I'm requesting the 12 months, and I just want to make sure we're clear here. The defendant's child was dropped off by, my understanding is the defendant's boyfriend at these people's home. They found the child wandering in the front yard. They went out to get the child for help. The defendant was out partying with these people's friend at a bar, came back, became irate, did a whole bunch of damage while her child was screaming inside. So I don't think that this is fair to say that this is a mother upset about the circumstances of her child. I think this is a mother that made some really poor decisions and her child got involved in it. CPS was called and investigated. I don't know the outcome of that investigation, but I take serious pause at this version of events because that is, I think, a gross understatement of her conduct during this time. I think that she needs to take accountability for the fact that her child was put in danger partly because of her actions that night. And these people were trying to help her child that was wandering around their front yard while she was out partying.
Your Honor, if I may respond to
You
that.
may.
Thank you. That the child was with a custodial parent who dropped the child off at an unknown location. It is not Ms. Mays, if the child was with another custodial parent, is still an adult and has the freedom to go out and do what she wants. While she is not proud of and does not condone her behavior from that night, it doesn't mean that the panic that set in, that when she found out that somebody else had her child who was not supposed to have her child, that the panic didn't ensue. That was my argument, not to make light of anything that Ms. Mays did, but simply to give some context as to her mental state at that time.
Thank you. Looking at this in the context, and Ms. Mays, I've had the opportunity to see the report. This is from the no contest plea stemming from February 19, 2024. The real problem here, in my opinion, is the drinking involved. Okay, that's where this all stems from. I don't know if you'd make some of the decisions you made if you weren't so intoxicated, and then you made some poor choices, and maybe choices that seemed very reasonable at the time, but on retrospect, they were somewhat unreasonable. And I think it all stems from you have to take a good look at your relationship with any type of controlled substance or alcohol, because I don't know if you act this way normally, but this was an event that occurred primarily because of your intoxication, and that's not going to change. All right, whether it be 3 years from now or 4 years from now or 10 years from now, your relationship with intoxication and alcohol and controlled substances is not going to change. So you need to pick a path. Okay, you're going to have a destructive path where you're going to see a lot of district court, maybe some circuit court, or you're going to see a less destructive path where you're able to put some harness. I don't know what your relationship with is in alcohol, but I certainly hope you don't act this way all the time. And if you don't act this way all the way, you want less of this. And that stems from, so my sentence in district court may seem to be not to help at this time, okay? But it's meant to help. It's meant to be, and district court's supposed to be a helping court. It's not supposed to be a punishing court, okay? But I'm hoping that I help you figure this out, all right? Because, and you may or may not have already. I don't know, all right? I just know that you must have better things to do with your time than spend it with me on a Monday afternoon, okay? But we have children involved. You're the mother of a child, you're the mother of children. And so we got to get this right, okay? At least trying to start to get this right. This was a no contest plea with a Killebrew, no jail, no upfront jail. I'm going to follow that recommendation. The restitution will be determined. I'm going to set it at $1 and then allow for restitution hearing if we have any. So I'm going to do a stick and carrot kind of thing. All right. For the no contest plea, you spend 1 day in jail beginning June 24th, credits given for 1 day served. I'm gonna suspend 30 days upon successful completion of probation. That is kind of the stick. Okay. If you don't do that, if you screw up probation, I've got 30 days to work with. All right. And I don't want to work with that because I think children should have their parents. But you've got some things to figure out here. All right. You've got some things to really figure out in the next 10 months. I'm going to reduce this by 2 months to 10 months. I'm doing that mostly because I'm going to hit you with fines and costs on this. And I'm going to hit you with everything else related to the alcohol assessment because I think it's time to kind of figure out if you're going to have a destructive relationship with alcohol or some other relationship with alcohol. And as everybody I've told knows, Ms. Wicks has heard this, Ms. Sutter's heard this, Ms. Wilson's heard this, is that I'm not concerned about you for the next 10 months. Okay. I can put you in jail and allegedly you're not supposed to drink in jail. Okay. It's 5 years from now that I'm worried about you. Okay. 5 years from now, you got to make good decisions. You can't do this again. You have to be a better parent on some level. And that's what we're working. And you never stop being a parent. You never. It never ceases. Okay. They may grow older, but you don't stop being a parent. It's not like you turn that off. All right. So I'm gonna do fines and costs. $200 fine, $200 cost. Crime victims' rights fee of $50. State minimum cost fee of $75. Restitution is $1. So you may have more restitution, you may not have no restitution, okay? Or you may have the $1 restitution. I'm going to put you on probation for 10 months, which is $300, set for $300. So I'll give you a grand total of that. 75 is 50 plus 300 plus $1 is $826. Probation is for 10 months. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. If you present a medical marijuana card to probation and you have the appropriate documentation, then we will use that. I'll allow that in this situation. Submit to random PBTs or urinalysis as directed, and no bars or nightclubs. It's the PBT or urinalysis. It's the random testing that's going to get you. Okay. If you're testing dirty and we find out and we violate you, then you and I see a lot more of each other, and then I get really worried about you as a parent. All right. If you're able to do this over 10 months, then I get less worried about you. And then I think, well, maybe 3 to 5 years from now, we're going to be in a safer environment. All right. I think all this stems from a destructive relationship from alcohol that lends itself to making bad choices and then striking out. All right. I don't think you're naturally a violent person. But I do think that given the right circumstances, you can be pretty violent when you want to, all right? And you certainly were on this date, had the opportunity to read the no contest. So I got an opportunity to see some of the facts in this case. I see the pre-sentence report. So I'm just worried, okay? I'm worried. I'm worried for you and I'm worried for anybody who cares for you. That's my greatest fear. Complete assessment and follow recommendations. Moral recognition therapy, I think if the funding is there for, would be a good idea. Obtain and maintain employment, not purchase or possess firearms, ammunitions, or weapons of any kind. We're gonna make this look pretty. Are there any questions concerning the court's judgment of sentence? First of all, Ms. Meigs. All right, you understand what we're getting at, all right? That you understand what my fear is, all right? Ms. Wicks, any question concerning the passing of sentence?
No, thank you.
All right, Ms. Wilson.
Just briefly, Your Honor. So is the judgment reading MRT only if there's grant funding available, or MRT and with funding if available?
It's reading. This is out grant funding if available for MRT program.
Okay.
That's
Yep.
that's the special
Just want to make
language.
sure.
Yeah, you're right. I've got to get the special language written down. The restitution may be as little as $1. We may have a hearing if we hear within the next 30 days. Okay. All right. With that understanding, I will sign it. Anything else for the anything else for the record, Ms. Mays or Ms. Wilson?
Nothing
No
people.
tether?
Yep.
All
Just
right.
good. Nothing from defense.
All right. Ms. Mays, good luck to you. And hopefully we can put this behind us and make this a learning moment. Okay. All right. Thank you. Ms. Rivera.
When I take from conversation first, and then we'll get.
Oh, yeah, I'm fine. Well, Bruce, I can find that. Yeah.
Find out what Trinity and Lisa. Let's get done with the criminal talk.
That's why I'm back in the early, so we'll give her a minute.
Yes.
Can we talk to Jacob real quick about Bird?
Yes. It's Derek.
Yes.
And Christina Green, mine is at 2:00. Okay, it's Christina Green. And Christina Blaine.
Oh, is she in Mark?
I didn't think so.
Well, she went to get Mr. Bird. He went to get Bird.
Bird,
Yeah.
okay, that would make sense.
So,
She said he went to Bird.
okay, yeah, he's getting Bird.
It's like, that one I accepted. Thanks, Wendy.
You're welcome. I'm trying to find the training video for my new court officer.
Oh, fun.
Probably not gonna think so, but I'm not doing all the silly stuff. I dislike.
Just join the club, I think. I haven't heard.
Whoever
anyone who
wrote
does
that
like it.
program has never worked in that program.
Yeah, no, I find that to usually be the case.
I want to scream.
It's going to have my hours back, and they don't give that to me.
Were we ready to go on the other one?
Which
She's
one?
not here.
Oh,
Yeah, we'll check the hall really quickly, but
that would be a negative.
yeah.
I'm just trying to wrap up our crim docket.
That's fair.
We got civil.
Yeah.
No, I just do basically food, gas, and car payment, in that car I was supposed to buy.
No.
I totaled my previous car and I was looking for jobs in Pearl State.
Yeah.
All right.
I'm just leaving there to finish your stuff, come back.
I'm looking for something that will actually give me, a better income and.
You know what, I answered is not which I can.
The latter, right now, it's that end, and I would like to determine if I can. And get a to sustain myself.
They were super glad you made here, Jack, because they are.
All right, so we're on the record in docket 22-00567. That is People of the State of Michigan versus Derek Bird. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson, 15 people.
Ms. Sutter.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Bird, who is seated to my right.
And sir, you are Derek Bird, is that correct?
Yes, sir.
Thank you.
Your Honor.
This is the time set for a probation violation hearing. Ms. Wilson, how are we proceeding, or would you like to defer?
Thank you, Your Honor. I believe this is going to be an admission to the violations, and there was some discussion between the court, defense counsel, and I in chambers about a potential sentencing arrangement, but I will leave it to the court.
All right. And is that a fair statement, Ms. Sutter?
It is, Your Honor.
The main admission is towards the one that previously discussed, which is the fail to appear. Is that correct?
That's correct, Your Honor. I believe it's violation number 3, failure to report in October, November, and December of 2022.
Question about that, how do I make a payment, because I don't have a bank account. And all I would get, like right now, I'm just, if what I
All right.
earn, I get cash.
Ms. Sutter, may I inquire of your client of his understanding of the probation violation admission, and then his understanding of his rights today, that he has right to hearing?
Yes, Your Honor.
All right, Mr. Bird, you understand today is set for a hearing. You have a right to a hearing today to have anybody prove that you violated your probation. We would have the probation officer come in. You are represented by Lauren Sutter today, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? Okay. It's my understanding it is your wish to admit to the probation violation. Is that a correct statement? Okay, let's have you raise your right hand as best you can. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
That's right.
All right. You understand you were on probation, and a probation warrant was sent out for you by Nathaniel Neves, co-signed by myself, and it was for failure to appear and failure to go do anything along that lines with probation in regards to October, November, December of 2022. Do you admit to violating your probation by failing to appear for those 3 months in 2022?
Yes, Your Honor.
All right. I find the violation of probation to be knowing, voluntarily, and accurately made. And Ms. Wilson, would you like to be heard on any allocution?
I think the discussion that the court and defense counsel and I had in chambers is appropriate here.
All right, Ms. Sutter.
Thank you, Your Honor. I'll just, I suppose, recap the discussion. Ms. Wilson is correct. There was a meeting between myself, sister counsel, and Your Honor in chambers regarding the recommendation and sentencing for Mr. Bird. That my belief being the court is inclined to order 120 days of jail here with termination of probation. It was my suggestion that the court allow that time to be alternatively served at an inpatient treatment facility. which Mr. Bird and his family are already in the process of trying to arrange. Specifically, Rise Recovery is the program he's been looking into. It would be my request today that the court do follow that discussion we had in chambers, being the termination of probation with that jail sentence and allowing him to serve that time at Rise Recovery, as I think we all agree that does him a little bit better than just sitting in the Ingham County Jail. Beyond that, I'll leave it to your court, to your honor's discretion. Thank you.
Thank you. Pursuant to the recommendation and some discussion concerning this matter, we will unsuccessfully terminate your probation. I'm sentencing you to 120 days in the Ingham County Jail. I will allow for day credit for any time that you can spend in inpatient, okay? My understanding is you're working to get there. I understand the rules of inpatient are different depending on the proceeding, but your rules are you get day credit for inpatient, and you'll treat that like you're in the Ingham County Jail. Some have a lesser, more lax policy as far as lockdown proceedings. Some have a much more. But if you choose to leave, then it's like you're leaving jail, and we're just going to treat that as you made your decision. All right. But I also agree that that day credit in inpatient can be much more helpful than just your days in the Ingham County Jail. So 120 days unsuccessful termination of probation, 120 days Ingham County Jail, day credit for inpatient. If you're able to get into inpatient and it's a shorter stay, you'll finish out your time in the Ingham County Jail. All right, sir?
Yes, sir.
All right. Anything else for the record in 22-00567, Ms. Wilson? Ms. Sutter.
Just confirmation, Your Honor, that their outstanding balance for Mr. Bird is being forwarded to collections for him to arrange payment after release.
Any outstanding balance will be referred to collections. Thank you. Do you have any questions concerning your sentence, Mr. Bird?
No, I don't.
All right. Good luck to you, sir. Okay.
Oh, yeah, I'll do my team in contact. I only thing is, only number I have is to thank you, but I don't know how she can get in contact with honest. Get what I need to get, we will take.
Is this Guevara here?
I haven't seen her yet, Your Honor. If you don't mind, she's always come to court, so if you don't mind, I'm gonna go give her a quick call in the hallway.
All right. Yeah, but she didn't show up for a PSI, and so there's. But
no comment.
Do your best.
Thank you.
All right, let's let everybody in the civil in. Let's see. I think we have one. Ms. Wilson, you're here. I
just have Guevara left.
Guevara's left. Okay. Oh,
Try and get an answer quickly. No problem.
23-02404. Lake Trust. Miss Barta, what case are you here on?
Good morning, Judge.
Mr. Barta.
Good afternoon. Portfolio recovery versus Miss Winston.
All right. That is the one paper file I do have. Is there a Miss Winston here?
Yeah.
You can come forward now. I'd go ahead and have a seat right there and I'll call that case. So on the record in docket 23-00913, that is portfolio recovery versus Ukiah Love Winston. Will the parties please introduce themselves to the record? Mr. Barta.
Good afternoon, Your Honor. Suzanne Barta, P65425 on behalf of the plaintiff.
All right. And ma'am, you are Ukiah Love Winston?
Yes.
All right. This is the time is set. I believe this is previously set. We had some technical difficulties. And so, Ms. Winston, you've made a motion to compel arbitration in this matter. Is that correct?
Yes.
All right. And this order, arbitration is usually done in regards to an order where you're indicating there's litigation concerning how you got to the order.
Say it again, I'm sorry.
But this is a collections issue, is it not?
Contract, yes.
Yeah, and so the litigation for the previous, that was already decided. This is just a decision on how much you're gonna pay.
So what I'm asking arbitration on the case is, you're saying it's for previously, it's been previously decided.
It's been previously decided. Yeah, it's and that's part of your argument, Mr. Barta, as I understand it. But I have the order. This was previously done from an order.
Yes, there was a motion for summary disposition.
It was a motion, yeah, it was a motion for summary disposition out of September 27th, 2023. And that out of that order comes an order in favor of the plaintiff out of that summary disposition. And then you have the collections issue. We're now in the collections issue. We're not going to relitigate what came out of that order.
Okay, so I'm asking for arbitration because via the synchrony contract, this venue was supposed to never been the issue. This issue shouldn't have been brought into this court. It should have been arbitration.
Sounds like you're relitigating the contract then.
Relitigating the contract.
Right. There's an order out of the summary for disposition that indicates how much you owe.
Mm-hmm.
I'm not going to relitigate what led up to that. You're indicating that now you want to take that order and you want to go to arbitration on it. And that's not a thing. You can't do that.
Okay, so me filing the motion is you relitigating, asking for the motion?
You were going back and relitigating your contract. Yeah.
Yeah, I don't understand.
All right. Mr. Barta, your response? So you understand the nature of the motion and you filed a response to the motion?
Yes, Your Honor. First of all, arbitration needs to be pled in the first initial pleading. So if in fact she was asking for arbitration, it would have to be pled in her initial answer to the complaint. However, that being said, once a motion for summary disposition has been granted by Your Honor and argued by both sides, the only available option for Ms. Love is to file a motion to reconsider or appeal to the higher court. Everything you're saying is correct. Filing a motion to vacate judgment is not really the proper process at this time.
I granted the motion for summary disposition was signed in September of 2023. And then you filed this motion for arbitration well after that date in wanting to relitigate the proofs concerning what I'd already followed the summary for disposition on.
I never received the judgment.
You were here when I made the judgment.
Right, I understand, but as far as knowing the.
And I signed it on the record. I have here orders signed on the record.
Right, I understand what you're saying, but when I didn't know the process of appeal and what my rights were because I never received the judgment. It wasn't read to me when you signed the judgment. It was told to me.
It was given to you.
They said they would mail it to me. And so then I called in and spoke to your clerk and told them that I've never received it. And then they sent me a letter of a judgment. They never sent me a copy of the judgment. So when I received the information, I just received something in the mail from them regarding the collections. And that's what I responded to because that's what I received.
But you're asking for arbitration on a case that's already been decided, a collections case. I can't grant you that arbitration.
But the original venue should have been arbitration to begin with, because it's stated in the terms and conditions.
I granted the motion for summary disposition as provided. That was provided by both counsel, you and counsel were here when I granted that motion. And now September, October, November, December, January, February, March, April, May, June, 9 months later, you're asking for arbitration on something that was decided 9 months ago. It's not going to happen.
Okay.
So based on the arguments made by both yourself and opposing counsel and the response to defendant's motion to stay judgment and compel arbitration based on the summary disposition that was made in September of 2023, I'm going to deny your motion.
Thank you, Your Honor.
So that's denying the motion. I want to make sure to deny motion to stay judgment. And compel arbitration. And Mr. Barta, you'll follow it up with an order to that effect?
I can do that, Your Honor.
All right, thank you. I will sign that's orally done. I will sign the order by e-file, which would make it easier. Miss Winston, you may want to get either some legal help or go to michiganlegalhelp.com. It's an organization that provides some assistance to see where you are right now, but you're past an appellate date. And by indicating that you want to do arbitration now, you're kind of telling me that this has become kind of unwieldy for you, legally unwieldy. So you may want to go to see what options you're on the internet. MichiganLegalHelp.com is the source. They can't represent you, but they've got laundry lists of different type of proceedings, and that might help you. Okay. All right. All right. Anything else for the record in 2300913, Mr. Barton?
No, sir.
All right. Miss Love, you were all, Miss Winston, Yukia Love Winston, you're all set. Thank you for your appearance today.
Thank you.
Miss Wilson, there's Miss Wilson. I'm assuming we have Miss Miss Guevara here.
She is on her way, Your Honor.
She's on her way. All right. She is. Yeah, I know. That's true. All right, Ms. Hoffman, you're here on the 2 o'clock.
Yes.
And that's Lake Trust. Make sure I've got the Lake Trust versus Shamari Allen.
Yes, that's correct, Your Honor.
Right, Miss Allen's here. She can come forward. Miss Allen, you might want to choose a different T-shirt to wear.
Sorry, I was doing laundry.
Yeah, then to choose that one in the court.
I didn't even think about it. I was doing laundry, cleaning kids, and I had a rush here.
Something to think about. Okay. All right. So we're on the record in 22-02404. That's Lake Trust Credit Union versus Shamari Allen. Ms. Hoffman, your appearance for the record.
Yes, good afternoon. Doreen Hoffman, P42231 on behalf of.
And ma'am, you are Shamari Allen, is that correct?
Yes.
Shamari Allen, thank you.
Okay. Okay. Do you want to start? I'm not gonna go back and forth.
All right, this is the time set for a is this a hearing in this matter?
It's her defendant's objection to garnishment.
All right. So you have an objection as to the garnishment, Ms. Allen, is that correct?
Yes.
Let me see if I can pull that up.
Stop talking on her. Stop talking on her.
let me find the objection as to garnishment. And I'll read that to the record. All right, so you have an objection as to the garnishment that was proposed, and your indication is that there are bankruptcy proceedings, and then you follow that out with the number. Is that correct?
Yes, I had filed bankruptcy. They was included. I did everything I was supposed to do on my end, but when I came here, she told me that my attorney never submitted bankruptcy papers to the court. So I had a stack of papers and she took the number down and told me to come to court.
All right, so usually we get a stay of the proceedings for bankruptcy. Usually that's the order that's provided, and then I sign the bottom of it and stays whatever collections issues out. So
Your Honor, if I may.
Ms. Hoff.
Yes, I was gonna say.
Ms. Hoff, in your response.
Yeah, I could clear this up. It's true she did file bankruptcy, but she filed bankruptcy on March 14th, 2018. She didn't apply for our financial services until May 17th of 2018. And then she had our services until she defaulted on those of July 9th, 2018. I personally looked at the bankruptcy records on using Pacer, made a copy of her schedules, and nowhere is Lake Trust ever mentioned because she didn't have an account with Lake Trust when she filed bankruptcy. She was discharged with regard to every other creditor, but because she didn't even have a debt with us until after she filed bankruptcy, obviously we're not included. I checked the docket just to make sure that there wasn't any supplementary proceeding adding us as a creditor, but we were not. And so
that's not true.
Again,
they were added. I had to go back. They wrote me.
I looked at the schedule. No, your information is incorrect. I actually loaded down.
I went to my attorney's office.
Do you have any proof that
it's 7 years old. I got a stack of papers, but I missed some. But I went to the attorney's office. My attorney retired, so they've been trying to scramble and stuff. But Lake Trust specifically was added because they was hounding me. They were added for sure, and it was definitely not in March. They were added. I remember.
No, you're incorrect. And you can get those records yourself from the bankruptcy court. I downloaded those today. You filed March 14th, 2018. Bankruptcy records don't lie.
You're absolutely right, but I know Lake Trust was added because she gave me I had a stack of all my
anything
creditors.
in writing that indicates that Lake Trust was added?
I've been trying to reach out to the company, but considering my attorney retired, they're making me go through a whole bunch of stuff. So I don't know. I mean, I had documents, but some of my papers is missing. But I remember Lake Trust being added because they used to hound me.
This has been going on since December of 2023.
I haven't received none of that. And then looking at the court papers, they got old addresses. One of them say Flores, one say Warwick. It was 3 different addresses that I don't even live at. So a lot of stuff I have not received until I got a garnishment. And then I came down here and none of the addresses are my address.
Ms. Hoffman, response.
Your Honor, this is an objection to a garnishment. It's not a motion to set aside a default judgment. One reason why it did take time to find her or file this action is because, as she's indicated, she's lived at different addresses. She has no valid basis for the objection to garnishment, and I ask that it be denied. And if she chooses to, she can always file a motion for installment payments, and we're more than happy to review that.
I don't want to do that because the Lake Trust was added. I know for a fact they was added.
There's nothing to indicate at this point that Lake Trust was added.
So whatever she's looking at, I want to look at too, because I remember getting a single paper when
Let's have
they
a
added
hearing
them.
on it.
That's fine.
So you have to be here.
That's absolutely fine.
Ms. Hoffman has to be here. We'll bring in all the paperwork. You, of course, will bring in your paperwork. Is that correct?
That's
a
fine.
yes?
I'm just waiting on.
No, I'm
gonna try to get whatever I can get. My attorney retired though.
What's your attorney's name?
Barrett Law, whatever.
No.
Now it's Osborne and Barrett, but when I reached out to them.
And what's the name of the lawyer who retired?
I don't remember his first name. I just called him Mr. Barrett.
You don't. And how did you spell that?
Barrett, right here on South Cedar.
All right. So Ms. Hoffman, let's set this for hearing, I think is the way to go on this. The garnishments to continue. This is your objection. We're setting your objection for hearing, and you can bring in any paperwork you want. I think setting it for 30 days out would probably be sufficient.
So considering I can't afford no $600 garnishment, what am I supposed to do?
Somehow afford $600 for the next month.
I can't.
I'm not going to grant any objection to objection to garnishment until I see paperwork. Right now, they're indicating that this is an invalid objection.
Yeah, whatever they say, whatever, but I know it was added.
Okay,
were
well,
not. But if you
yeah,
give me your-
I'm gonna give you the opportunity to prove it.
And if you give me your email, I will send you the schedule so you can review that yourself. And maybe it's something you have to take up with your attorney. Maybe they didn't do what you asked them to do, but I'll send that to you.
I don't know, but I can't afford $600.
All right, and what we'll also do is I'm gonna set this for formal hearing. For a hearing on the objection. I should say it
So
in those terms.
adjourn this one until you said 30 days.
Yeah,
out?
and we're gonna have a hearing and we'll see, we'll wait for we'll wait for everybody to bring in their paperwork. Two things I'd like from you, though, ma'am, is we want, for the record, we're all on the record here, a good email address. So Ms. Hoffman can send you any address she needs. So what is a good email address for you?
ShamariLatrice@gmail.com.
Okay, and if you could spell that for me?
My first and middle name.
All right, so I'll spell it then. Yeah, and I'm just.
Yeah, Shamari what?
It's
Latrice.
Latrice.
At what?
At
gmail.com.
gmail.com. And just to make sure, I want to make sure we have the correct spelling on that. So that would be
Her first name I have is SHAMARI. There is no middle name.
all right. So I want to make sure we have the right name here. I'm just having trouble getting the computer to work.
Is there a dot between your first name and your middle name?
No.
Oh, just.
So there's no. I don't know if she's yelling at someone. I can't pull this. All right, here we go. I just got it. Let me pull up what I have so that we have the same thing, and then we'll match it with your address also. So I have Shamari Allen. You're saying Allen's not your second name, or it is?
That's my last name, not my middle name.
Okay, so Shamari spelled SHAMARI, and then how's your middle name?
LATRESE.
LATRESE, and then that's at gmail.com. And then an updated address for you.
2500 Lyons
2500 Lyons
Avenue, 48910.
48910, and that's Lansing, right? All right. All right, and we'll set it
25
for,
I'm sorry, was that 25 Lions, LIONS or LY?
it'll be LYONS, is that correct?
LY.
All right.
Avenue 48910.
Yeah, yes, 2500 Lions. And we'll set for formal hearing on objection for about 30 days out, I would think.
July 31st.
July 31st at 9 o'clock. And then Ms. Hoffman, you indicated that you would send Ms. Allen any paperwork or anything that you think she should see concerning the objection?
Yes, and it does have her bankruptcy attorney's information on it. I'll send her the full schedule and I'll also follow up with the court so you have it as well.
All right, thank you. And then that should have Mr. Barrett's name, full name and P number, and then we can get his retirement notice from there, okay? All right, so it'd be July 31st at 9 a.m. set for hearing. Please bring any document you want the court to consider for that date. So you have any documentation indicating that it is different than what Ms. Hoffman's indicating, you need to bring that, all right, ma'am?
Yeah.
All right. Anything else for the record in docket 23-02404, Ms. Hoffman?
No, all set, but thank you, Your Honor.
Thank you. Ms. Allen, do you have any questions of me?
No.
You're all set. Thank you for your appearance today.
Thank you.
Thank you. And we're still waiting on Ms. Guevara, right?
She is present.
Here,
Oh,
if,
she's here.
if the court wants to pivot back to criminal, we'll just go
We
fast.
can pivot back to criminal. Yeah, because we don't have a sentencing. I can't. So we're on the record in docket 23-03156. That's People, the State of Michigan versus Marcy Guevara. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Sutter.
Good afternoon, Assistant Public Defender Lauren Sutter on behalf of Ms. Guevara, who is standing to my right.
And ma'am, you are Marcy Lee Guevara, is that correct? All right, thank you. This is the time is set for a sentencing in this matter, but we don't have any, I don't have a pre-sentence done.
Correct, Your Honor.
So Ms. Wilson, how did you want to proceed, Ms. Sutter? And then we'll go from there. I just can't sentence and we need.
Yeah, Ms. Sutter and I had a brief discussion earlier this morning about this. We anticipated this being an issue. If the court's amenable, the people are prepared to give Ms. Guevara another try to get the PSI done. I don't know if the court wants to reset this. Obviously, if it's not completed by that point, then we're going to have another issue. But it sounds like there was some contact issue, and I have no objection with another attempt at a PSI.
Right. This is, and we have to have a PSI. This is a domestic. And this.
Your Honor, I apologize. It's just occurring to me. This is also a 7694A case, so we have to clear the courtroom.
She hasn't been sentenced.
Yeah, I don't think she's been sentenced. Technically.
Fair point.
Yeah. Technically, technically, I think it's she's got to survive sentencing at this point. And it was set for sentencing on April. We set it back in April of 2024. So.
And if I may, Your Honor.
Yes.
Thank you. Ms. Wilson is absolutely correct. This is a discussion we had this morning, acknowledging this was a missed appointment with the probation department. It looks like it was at some point set for June 17th. Ms. Guevara, in discussion with me, admitted that she believed it was set for the 18th. The Tuesday is the day she has off from work, so she had communicated with the probation department regarding doing the appointment on that day, found out unfortunately a little bit too late that it was in fact set for Monday, the day before. She got back in contact with the probation department. At that point, they advised, unfortunately, at that point, they would not have time to prepare the report prior to today's sentencing. I would also ask the court to consider resetting today. Ms. Guevara is a person who has shown up to every court appearance so far and has remained in extraordinary contact with me throughout the pendency of this case. This would be the kind of first slip up, so to speak, in terms of missing something with the court, acknowledging that it's not a great one to miss. She and I have had a discussion that it's now or never. If you miss the next appointment, then the decision is made for the court, and it's really, really important to attend that if there is any hope of avoiding jail here. I think it's very, 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 very clear to her at this point if the court is willing to allow a reset of today to get her through that PSI appointment.
All right. you understand, Ms. Guevara, you understand the issue we have.
I do, I do understand.
All right. We can't sentence you without a pre-sentence report. And we have to set it out for some time for this. And we come to a point where if we don't get a pre-sentence report, then we remand you for the pre-sentence report. And that becomes a problem because that means you're just collecting time in jail. And I'm assuming you don't want that.
I don't want that.
Yeah. But to your credit, I have seen, this isn't your first go around. Okay.
I
So,
appreciate that.
so we'll reset the sentencing, but we're gonna, once again, it's gonna be set out. So they can do a full, and what you should do is go down to probation.
I'm going right now.
Okay. Find out who, find out when, where, and they're gonna do a report. One of the problems we don't have is I don't have a report, so I can't sentence you. Next time, if I don't have a report and you're up, we're just gonna remand you. All right? All right. So let me set a resentence date for.
August 19th at 2 o'clock.
August 19th at 2 o'clock. So we'll reset, we'll try this again. Go down to probation, find out who, when, and where, and and just set it as a priority, all right? Anything else for the record in 2303-156, Ms. Wilson?
Not for the people, thank you.
Ms. Sutton.
Nothing further, Your Honor, thank you.
All right, Ms. Guevara, we'll see you on that August 19th date, all right?
Ms. Guevara, have a seat right here.
I need to do some
Walk you down to
paperwork,
probation.
Just a second.
All right, and Ms. Guevara, you do, I think you've got an outstanding civil infraction that
I
they've
think there was
got.
a, show cause non-payment.
Yeah, so let me make sure you should clear that up.
Just wait here. That's it.
Is there anybody here? Oh, the last one's. All right, Ms. Wilson and Ms. Sutter, I'll see you tomorrow.
Yes, you will, Your Honor.
Ms. Wilson, I'll see you probably Thursday or Friday.
Yeah.
All right. Then is it Alexis Spears? All right. And Tiffany Jackson Warner? All right, you can, so it's just Tiffany Jackson now.
Yes, sir.
All right. Ms. Spears, you can sit closest to the jury. All right, so we're on the record in docket 24-00010. That's Alexis Spears versus Tiffany Jackson Warner. Parties, please introduce themselves for the record. Ma'am, you are Alexis Spears, is that correct? All right. And ma'am, you are Tiffany Jackson, is that correct?
Correct.
All right. This is the time set for a formal hearing on the matter. I will indicate that we met on May 23rd. All parties appeared. We did do some discussion of the case, and we set it for this afternoon for today's date. And the parties had the opportunity to speak on this matter. I know you previously signed a document, and I'll read that into the record. It's already in, I saw it. Let me pull that up. All right, you both previously signed a document in this matter indicating that you understand you're giving up the following rights on this appeal from small claims. You're giving up the right to counsel, the right to jury trial, the right to recover more than $6,500, the right to appeal, and the right to remove to the general civil division as you removed it to the general district court division. And you both signed this as of May 23rd, 2024. Is that your understanding, Ms. Spears and Ms. Jackson?
Yes.
All right. So let's do this. So let's do this. We'll go forward with the hearing. What I'm gonna do is, I'm gonna swear in each side. First, I'm gonna swear in, Ms. Spears, and then Ms. Spears, anything that you want to enter as an exhibit, but we're gonna swear you in for your testimony first, okay? And then you can tell me what happened here. And you have the burden of proof as the plaintiff, okay? And then the defense can come and they can tell me exactly what happened. And we'll go from there, all right? I may have some questions during the process, so I may have some questions. I may relay some questions. I don't think it's a good idea to have you question each other, but I may relay some questions that I think are appropriate, all right? All right. And let's go from there. So Alexis Spears, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay. All right. And ma'am, you are Alexis Jemiah Spears. Is that correct? All right. Why don't you tell me what happened?
So,
And I'm going to have you speak up as loud as you can. And that recording actually goes to the recorders. So speak into that if you can, but I want to be able to hear you. We might end up turning off that fan if it's too loud.
Okay, I am here in court today because I am being asked to pay back money that was offered or given to me. For starters, there was an original $700.
Right now, so let me get this right. You're the defendant in the case, right?
Yes.
All right.
And I just.
Let's start with Miss Jackson as the plaintiff and go from there. Okay. All right. And my understanding is you've already litigated this once in front of the magistrate. All right. So with your first here, which is usually where the plaintiff is, you're under the defendant. So let's start with you, Miss Jackson. Let me have you raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Okay.
All right, Miss Jackson, tell me what happened here.
Okay, back in August of 2022, thought it was November, but I had the wrong date. I had to get verification.
So it was August of 2022.
August of 2022, I won $700 from online gambling. I thought I Apple paid it, but it was Cash App. I had my proof. I Cash App that $700 to Alexis to hold.
So you gave that money to Alexis.
To hold for me due to my excessive gambling at that time.
All right, and what is and how is she related to you? How is Alexis related to you?
She's my sister.
Okay. And she's not your stepsister, she's your full sister.
We have the same mother, different fathers.
Okay. So you gave her in August of 2022, you gave her $700. How did you give it to her?
I sent the Cash App.
Okay, you sent it by Cash App. And what was the nature of, were you giving it to her to hold? And so what do you remember telling her?
I told her, I said, just hold on to this. You know, I was gambling really heavy then. I said, hold on to this. Don't give it back to me until I tell you I need it. Just hold on to it. She said, fine.
All right. Did you give it, when at the time that you gave it to her, did you give her any instructions other than just hold on to it?
Just hold on to it.
Did you tell her the money was hers in any way?
No, I did not.
Did you tell her she could use the money in any way?
No, I did not.
What was your understanding she was supposed to do with the money?
Just hold on to the money until I needed it to keep it out of my possession from me gambling it back up. That's really what I was trying to do, because I had a really bad gambling problem at that time. So I had just won some money. I didn't want to just gamble it back up, which I knew I would have if it was in my account. So I sent it to her and I said, will you hold this until I need it and I'll get it from you? She said, okay, no problem.
All right. And all right, go ahead.
Okay. During that time, out of that $700, I had Alexis pay $250 for a family trip in December. She paid that for me out of the $700.
Okay. So, and do you have any writing or anything to confirm that you said it was okay for her to spend the money on that portion of the $700?
No, this was verbal at work. This was something that we spoke upon verbal. We both worked at the same place at the time.
So that would be $700 minus the $250.
Correct.
Okay.
Then also I had her send another $30 as a deposit for my nails.
And when was that?
That was also in December of 2022,
Okay,
which leaves a balance of 420. So we're gonna fast forward. May 12th, May 12th, 2023. Alexis gave me the money, the remaining of what I had out of the 700.
so she gave you $420.
Correct. She gave me my money.
What date was that?
May 12th, 2023.
And at that time, she owed you no money.
No money.
All right.
Okay, that night, both her and my daughter, they went to a party in Detroit. Some kind of way, Alexis ended up running and messing up both of her ankles that night at the party. So when they came back the next day, or that night or whatever, and she came over the next day, both her feet were in boots. Her job at that time was patient care tech, so she was not able to work. She didn't know what she was gonna do for money, things of that nature. So I looked at her, I said, here, you take the 420 back. I'm gonna give it back to you. When you get back to work, whatever you got going on, give me my money. Okay, fine, no problems.
That was on May 13th.
Yep.
All right.
Fast forward to July. July 29th, Alexis called around to borrow $3,500 for her car. Her car was being repossessed. She was behind in her rent. No one would help her borrow. No one would let her borrow the money. At that time, she was looking forward to a lawsuit from Airbnb. She had put in the lawsuit papers. She was doing her doctor's appointments, everything that needed to be done for Airbnb to pay her because she was suing them for messing up her ankles on their property. So she, okay, it got so bad to where Alexis was talking about driving her car into the river, things of that nature. No one would let her borrow the money. So she called my daughter's boyfriend, asked him to borrow the money. He took her through a long run around, wouldn't give it to her. So I called her. I said, look, sis, I don't have $3,500. I said, but what I will do is I'll help you keep from losing your car. That's the best I can do. I don't have the extra money. I said, so I'll help you keep from losing your car. But this is a loan. I want my money back. This was never not a gift. This was never, I'm giving you this money, none of that. So the balance of the car was $1,450. She came over that next morning. She said they needed to pay it by noon. However, I guess they called her early and said they needed the money before noon. So she called me, told her, come to the house, get my debit card, call Kia, pay Kia. She paid Kia the $1,450. I have verification of that off my bank account.
Okay, so that's $1,450 to Kia. And that, what date was that done on?
That was done, oh Lord, I can't, July 31st.
That's July 31st of 2023.
Correct. I just want to kind of iterate what kind of goes hand in hand with this. During the time of May 23rd through September, Alexis was, out of job. So me being the big sister, I just tried to be there. So I bought her groceries, took her out to eat, paid for round trip tickets to Dallas, summer clothes, etc. Just trying to support her and be a big sister. And after that, she ended up moving into my house in October. October 14th, she moved in. Once she moved into the house, it just kind of changed. It seemed like, she kind of was either in her room or gone. So, we never really communicated during her stay there. So we had a situation on November 27th. It was getting late. So I asked Alexis, could she go to the dispensary for me? She went to the dispensary. And she came back with the receipt. The receipt for me was $63. November 28th, Alexis called me for her money from the dispensary, $63. I said, how much? She said $75. I sent her the $75, but I let her know that that's not what she paid. And if this is what we're gonna do, then when will you begin to?
All right, so you got a receipt for 60, you saw the receipt for $63 and you paid her $75.
Yeah, because she said her coupon didn't work for me.
But you okayed the $75.
Yeah, I did. I'm not gonna go back and forth over $12, $13.
All right.
So it was like, I kind of felt like that was a slap in the face to me because it felt like everything I did for her. Are we gonna really be this petty over $12, $13, you know? So that's kind of where I was like, you know, at that point, she had a trip booked for, if I'm not mistaken, Miami. She had different $100 shoes coming through the mail, getting shipped to our house. So I'm like, you know, when are you gonna start paying me some of my money? Her response to me was, what money? I never told you that I was gonna pay you back. I never told you I had a lawsuit coming. Nothing. As if I was just giving my money to her, just to give it to her. And that's, I'm gonna say, I mean, I have my own car note, Your Honor. If I'm gonna pay a car note, I pay my own car note, you know, so.
Do you have the $14.50, the amount that you said you had it? All right, let me see that. And we'll have that. Thank you. Thank you, Miss. Stay back.
Slaviak.
Slaviak.
Close enough, right?
Close enough. Slaviak. All right, let's mark that. You can mark that as Exhibit 1. Plaintiff's Exhibit 1. Sorry. And Ms. Spears, have you had the opportunity to see plaintiff's Exhibit 1?
Yes.
Which is okay. All right, Miss, so I'm gonna, are you requesting the court review plaintiff's Exhibit 1 at this point?
Yes.
Any objection, Miss Spears?
No.
All right, without objection, the court will admit plaintiff's Exhibit 1 into evidence. And I'll review it. So that's the $14.50 you requested.
Right.
Now, just for my own edification, the $63 receipt, does that come off the $14.50?
No, I gave her money for that. That's nothing to do with this. This is totally different.
So this all stems from a $14.50 debt of July 31st, 2023.
And the remaining balance of the $700.
But my understanding is that $700 was all made good.
It was $420 left.
There's $420
She
left.
gave back to me on the 12th.
Then you gave her the $420 back.
On the 3rd, on the 13th, because she was not working. Her feet was in 2 boots. And I told her, here, you hold on to this. You need it more than me right now.
And that's separate from so it's $14.50 plus the $420.
Correct. And this is the Cash App receipt from the date and time that I sent her $700. I didn't have that previously, so I was able to obtain that.
All right, why don't you let me see that? Thank you, Mr. Slaviak.
You're very welcome.
All right, and Miss Spears, have you had the opportunity to see the $700 cash? All right, is that a yes, ma'am?
Yes.
All right, go ahead and mark that as People's Exhibit 2. So any objection to me reviewing People's Exhibit 2, Ms. Spears? Without objection, I'm going to move to admit plaintiff's Exhibit 2. So my understanding of the request today is for 1,450 plus the 420 for a total of $1,870. Is that correct?
That's correct. Also, I don't know if it works, but the lady told me I could, add the court fees and costs in there.
Yeah, and we'll get to that.
Okay, that I had to pay for,
All right.
to be served and everything.
All right. Anything else you want to tell the court? I think you've answered my questions, and I'll give the opportunity for Ms. Spears to ask me any questions, but I want to get her side of the story. Anything else?
I'm just really kind of think it's redundant that we're in here, you know. Like I said, I tried to be a big sister to her. Both our mom is deceased, so I'm kind of like the next thing under mom. I'm 46, they're 23, so you know, I just try to be there and support them. And it was like once she got my money, I haven't spoken to her. It's like I don't care no more, you know. She hasn't said one word to me. I can go over to my dad's house. She'll totally go the opposite way. I have not done anything wrong to her, so I just want this to be over with.
All right, Ms. Jackson. Ms. Spears, you were previously sworn in. You know the allegation now. It's been litigated before. Why don't you tell me your version of this?
So I'm not here to object the amount that she's given or paid, like we both agree on that part. The part that I'm disagreeing on is the communication or the agreement that we came to when doing such. So in the beginning, she sent me the $700. When she sent it, there was no text or anything that came through. It was towards the middle of the night, like, you know, it was late. She didn't send a text with that. Later, I learned what it was for, and she did ask me to hold it. She did ask me to send money here and there, nail appointments, family trips, whatever she asked me to send it, or whoever she asked me to send it. I did do that. May came, I did go out with her daughter, and before I went out with her daughter, I found it appropriate to pay her back before going out. I gave her money, and the next day I came back injured. And she was like, well, dang, like you're not gonna be able to work or whatever. So she gave me the money back. And again, no communication. She just said, well, here's this, I'm sure you need it more than me, kind of thing like that. Now, I gave it back because I knew I had to give it back. She never gave it to me to have when she gave me the 700, which is why I paid her back on May 12th. That was the communication I had with her. When she gave it to me on the May 13th, there was no communication there except for, well, I know you're not going to be able to work. You need it more than me. Okay, cool. Moving forward, my car was being repossessed. As she stated, I was asking everybody. I reached out to different churches and things like that, people who will help once you get so far past due with bills and things of that nature. I had a couple people who were swaying, they were going to help, but they needed this and it was going to take this amount of time. And really, I needed like the fastest thing because it was in repossession status. They were looking to come and get it. I was on the phone in her kitchen, talking to her daughter's boyfriend and different people on the phone. And when I got off the phone with them, I didn't have a yes or no, just a maybe basically. And she was like, you don't have to beg anybody to pay your car. No, you don't have to beg anybody for money, not your dad, not this person, not that person. How much is it? And I told her, like, this is what they're saying I need by tomorrow morning. She's like, well, she said she couldn't pay it that night, but come back in the morning and she'll help me. I was like, okay. So I went home, and the next day I called her in the morning. I'm like, hey, they're actually calling me earlier. Is it okay if I come over and take care of it now? And she was like, yeah, come on. Get there, she takes care of it. Again, no line of communication there. No, nothing was ever discussed about it. And the people I was asking previous to her was not hey, can you give me this so I can pay it back to you? Like the churches and the people that are reaching out to, they weren't going, it wasn't something I had to pay back. They were going to help me out, and then it would be a year or a couple two before I could ever reach out to them again and get help, kind of thing. Like that was their rules. So that was my whole thing. Okay, later down the line, November comes around, Thanksgiving, we have Thanksgiving at her house. Well, October comes and I move into her home, start paying rent for the room that I'm living in. And then November comes and we have family in town, and I'm living with her at this time.
And while I was living with her, I didn't spend much time anywhere else in the house other than my room. It wasn't any real reason. I just spent time in my room. When I came out my room, it wasn't no like not speaking or anything like that. Like when I came out of my room, I spoke to everybody. I went about my day, whatever I was doing. 2 days after Thanksgiving, we still have family in town. They were leaving the next day, and she was getting her hair done. It was late at night. She was like, "Hey, will you run to the dispensary for me?" I'm like, "You know what? I actually need something from the dispensary too, because I have a coupon I want to use." She's like, "I do too," as in she has a coupon she would like to use. Okay. She said, I think she sent someone to get her purse or something. They didn't get it. So I was just like, well, they're about to close. I'm gonna just run and grab the stuff, and I'll come back. I'll just get my money from you. So I never got the coupon. I never got her payment. So I went, I spent my coupon. I asked them, I'm like, are we able to split like up the like thing? Can I put this on this bill and play with the coupon and put this and I'll pay with it separately? And they told me I couldn't. It was too late at night. I had ordered it all together. I had to pay for it all together. So that's why my coupon was attached to her order. When I brought the coupon back, when I brought this bag and everything back, I gave her stuff. I gave her the stuff in the bag with the receipt on it. It wasn't a secret when I paid for it because she knew she didn't give me her coupon. I didn't think I needed to hide it or anything like that. So the next day, she still hadn't given me the money for her order, and I texted her about it, like, hey, because she wasn't home. Let me reiterate, she wasn't home. If she had been home, I would have went to her in person and said, hey, can I get this? Because I believe communicating in person is a lot better than communicating through text, which is a lot of what we did while I was living in the house with her. She could be downstairs, she could have just seen me walk in the bathroom, and she would send me a text, whether it was to do the dishes. It's just, we never communicated formally in person and we lived together. So that's what I mean by the line of communication was never there. So when I got hurt in May, she had told me kind of like, well, you can get paid for that because they should have had those potholes in their yard patched up. So their people who came to the Airbnb didn't get hurt. So she was like, you can contact Airbnb, let them know you got hurt. So I did that. There was the worst lawsuit was never used because I didn't go through a lawyer. I went straight through Airbnb. I talked to them and they basically told me I had to submit every bill that I had from urgent care, every bill that I had from physical therapy, every bill that I obtained. I had to send in what my work schedule would have been like had I still been working, all of that stuff submitted. Still to this day, they have all my information and they haven't reached back out. So now I am obtaining a lawyer to get that situation dealt with. I learned in our mediation that the reason why all of this is even coming about is because she thought that I had a lump sum of money coming in. And I probably do, but I don't know this because they're not contacting me or reaching out or saying anything to me about anything. So my next process is to try and get a lawyer to just send a letter in and maybe get the process moving. But as of right now, I haven't received anything, haven't gotten anything. She mentioned all the things that she did for me after I was hurt or injured. Again, she was never asked for those things. I was always grateful of those things. I always, yes, I accepted them and I, told her thank you and things like that, because at the time I didn't have much going on. I wasn't able to work because of the job description I had. And I was trying to get them to accommodate me by like a desk job or something within the company and they couldn't do that. So I was just out of the job. I feel as though like all of this is coming about only because of the way I went about asking for my money back in November, which was just simply to ask for it back. I guess she felt like I should have made her pay the lesser amount with my coupon. I could have done that. Wasn't doing it illegally. It's just like you knew what you were going to pay originally. Like, she didn't have to do that. She could have sent me the $63. It didn't have to be an argument because I don't care to argue about this. No, I did not ask her straight outright if she could pay for my car note. She did offer after I got off the phone. And then it comes up later about her wanting it all paid back after the whole Airbnb situation.
Do you have anything in writing concerning either one of the 1450 or the 420 that was loaned? Was any of that put in writing?
About the exchanging of it?
Yes.
No, we don't even have text messages about it. I've searched our text messages. Like there was no line of communication.
I didn't bring in like a screenshot of Cash App or her bank account because I don't have that, but I do have the Cash App, but we're not here to disagree on the amounts. We're just.
Right, there's no doubt there's 1450 that
Yeah.
came and 420 that came later for a total of 1870. The question is that we have a different understanding as to what was linked to that, which is why people put things in writing. That's how people do business, is they put things in writing. And so there's not this, now I'm judging credibility and I don't know either one of you. And you're indicating that this was money to be returned, that was money that was not to be just given away. And and Ms. Spears, you're indicating that it was your understanding the money was just a gift on some level. Is that a yes or no?
Yes, I'm sorry.
And that creates a problem with me because the moving party has to prove their case, and she's got some exhibits, but none of this was put down in writing. None of this was put down. And generally, we don't think of those things when we're dealing with family. That's just the nature of it. And then you've talked about line of communications have been poor. Let me represent to you that line of communications are always poor between family. It just always seems to be that way. We tend to expect more from those we care about, and then we tend to get angry when we don't get what we expect, which is fair and unfair all at the same time. The real key here to me is that, as you know, I think it's unrealistic to as you've learned and as you've learned, it's unrealistic to indicate that you're waiting for a civil suit for Airbnb because it's going to take forever. And that's a big corporation and they're going to make it difficult and hard to be sued. And as through their website, because I'm familiar with how Airbnb works and all the things that you have to, and then you wait for them. And then and they may or may not deny your claim. And then you have to go from there. So it's unrealistic to ever indicate that money is realistic to wait on that money. I have some question as to whether she just give you the money. Okay. So is there anything you would tell me that would suggest that Ms. Jackson would just give you the money to make sure that your car was taken care of, other than just being a big sister?
Well, what she said in the kitchen was, and I had reiterated this conversation to her before we even got here, like before anything went to the court. When I got off the phone was, you don't have to worry, and more vulgar, but to keep it PG in court was, you don't have to worry about nobody for anything. You don't have to beg nobody to help you pay anything. Yes, I do have a living father, but I take care of him now. He's fully disabled. So it's like, she's telling me, like, you don't have to worry about nobody for anything. You've been going through it and dealing with this, like, don't worry about it. I'm going to help you with this kind of thing. And like, I would have much more appreciated her just be like, look, I don't got it. And can you have it to me by this time or something like that? That way I can deny it if I knew I wasn't going, if I couldn't live up to that, rather than just be smacked in the face a few months later, like, you have to pay me this back and stuff like that. Previous to this, she mentioned she bought me a flight and things like that. I was okay with missing my niece's birthday because I couldn't afford to get on a flight. She offered to pay that. I'm honestly quite surprised it's not being brought up here for me to pay that back, because I would not have asked her for that big amount of money if I couldn't pay it back to her, because I do know how she is. Not specifically with a situation with me, but she's had situations with my dad with money, and I just try not to get into it with her with money, because that's always going to mess up our relationship. It always has. So,
Ms. Jackson, do you have anything you want to say?
Yes, this is our first time ever having a money situation ever. Anyway, so let's just get that clear. Me and Lexus, she was coming over almost like every day when she got hurt. It would basically be me and her. we was talking, we were talking about lawsuit, we were talking about either her getting a job. She was trying to find something that could accommodate her, her disability at that time. But me and her, Alexis knows just as well as I know. And that's what I told her. I said, Alexis, when I paid your car note, I had less than $1,000 in the bank. So why would I give you my money and be broke? And she said, well, if you couldn't afford it, you shouldn't have gave it to me. And it's like, okay, when you needed the money, everything was fine. Oh, I'll pay you back. Everybody else you called, you told them you were going to pay them back. When she called my daughter's boyfriend for $3,500, she told him she was going to pay him back. Everybody she called around, she told them she was going to pay them back. No, you don't pay churches back because they give it to you. She knows that. Nobody came through for her. So again, like I said, she was at the last thing I heard, they said that she was talking about driving her car into the river. That's my sister. No, I didn't charge her for the Dallas trip, the clothes, the food, the outings, the this, the that, and the other, because those are things that I felt that I was doing just to be nice. But as far as my $1,450 and as far as my $420, I feel like she should give that back to me without a problem, because you know when I gave it to you that you were supposed to give it back to me.
You understand that I don't have anything but you telling me that.
Right, I understand that, but I'm just.
I don't have anything in writing. I don't know. I mean, that's why we put things down in writing, because that's why people do business. And that's why, because you're telling me that you gave it to her with strings attached, which are I want this money back.
Correct.
And she's telling me that there were no strings attached, that it was a gift.
That's what she said.
Yeah, and then I'm stuck trying to say who's proven their case and who hasn't. And I'm trying to weigh credibility, and I don't know either one of you. I don't think there's a dispute as to numbers. I just think there's a dispute as to, and I'm only talking about the numbers you're requesting. I'm not talking about all the other other numbers out there. But I don't see anything other than what's indicated that tells me that you wanted the money back, other than you're telling me you told her that.
Yeah, we had this conversation. Me and Alexis talked. The $420, she was supposed to have been paying back. That was done. The $1,450, she was supposed to have been paying me back. That was the agreement when she moved in my home in October. I would have never even let her move in my home if she wasn't going to pay me back. You know, it was like, come on, Alexis. I really went above and beyond, Your Honor. I have 4 grown kids myself. And if they owe me, they pay me back as well. She knows that. So.
Alexis, Ms. Spears, I'll give you the final say, and then I'll render my decision.
The whole, if you couldn't afford to do a thing, that was, she is right. We had discussions about when I would come over and couldn't go anywhere, it would just be me and her. We had a discussion about my dad. He can be tight with money, and one of the things she mentioned was if you can't afford to do something for somebody, then you shouldn't do it. And so when she came at me how she did, I reiterated her own words back to her, and she took it, I guess, different than how she meant it when she said it to me. I also, it makes me question how genuine she was being from the jump, because if I knew this was a business agreement, I would have made sure there was some type of communication, some type of writing, some type of, we need to make sure this is how this goes, to keep from the he say, she said, the do I pay her back, do I not pay her back? Because it was never a conversation of if I pay her back or not until November. This was before I moved in October. If she wasn't gonna, I was paying rent there in October when I moved in, and things like paying for my room and things. It was never mentioned then when I was paying rent, or hey, put a little extra on top because you're paying this up to nothing. Like, it was no conversation at all. And then now it's just out of nowhere. And I genuinely just feel as though it's because when we were talking before we made it to the courts, we were on a video chat mediation, and she said, and she has a lawsuit coming and she still hasn't given me my money back. I genuinely feel like she's only doing this because she feels like I'm owed some money, because she did help me with that situation, get all the paperwork and stuff sent in and how to go about it. But I think she's banking on that, and I don't have that. That, like you said, it's a long, drawn out process, and they have all my paperwork and it's no longer reaching out. So I have to go about it a different way.
Well, this is exactly why we put things in writing.
Yes.
Right? That this is, and I know we don't put in writing things with family. You know, I know that's how it works. With that understanding, when you ask the court to come in and you ask the judge to come in, we're looking for things in writing because that's how business is done. And since I don't have things in writing, I have your testimony. And the worst thing I can say is for the plaintiff is I don't know. I don't know. Okay. You could be telling the truth and you could be telling the truth. And I'm trying to grapple with it. And that's why we look for things in writing. And right now, what I've got are people telling me things that seem to make sense, seem to not make sense. But the question is, has the plaintiff proven their case? And I find that the plaintiff has not proven their case. I find I have nothing in writing. I have the hunting account that would indicate that the money is owed, and there's no dispute as to the numbers. The question was, is it a gift or was this done as a transaction? Was this done with the understanding that I'm going to get money back? And I have nothing to that effect. I have nothing in writing, nothing to that. And so my decision would be then that the plaintiff has not proved their case today. So that's what I find. I find the plaintiff has not proved their case today. I cannot say that this money was not a gift, okay, or that it was ever meant to be, because the plaintiff has not proven that to me. Because I don't know. I really don't know. That's the fact of the matter is. And the fact of the matter is, if I don't know, then the plaintiff hasn't proven their case. That is my decision now. What really kind of breaks my heart is the fact that I have two sisters in front of me, and I don't know if they'll ever be fixed. Okay, I don't know if this will ever be fixed. Two sisters in front of me who may not speak to one another ever again, and that kind of breaks my heart. All right, because we should be above this. We should be above finances and money and things of that nature. And I know it's easy for anybody to say that, but realistically, 10 years from now, you may think about the money, but really you're going to think about, gee, I wish I had my sister to talk to. Or I wish that person was there with me or for me, because life comes at you really fast and you don't know what's going to happen. And that's a shame. And I hope I'm wrong. I hope you can fix this, but I don't believe that the plaintiff has proven their case today. And so the case is dismissed.
So
All right.
do I have the chance to appeal it now?
No, you've signed the document. We're all done.
But she said that she's holding me to 420 and you're still not giving me that.
She said that it was based on a gift. That's what she said.
So the fact that I won the case before, I don't win it again.
This is a de novo review, and I can reread what you signed. You want me to reread the waiver that you signed, indicating that my decision is the final decision, and that you've waived anything else done up until this decision.
That's unfair for you to do that, but it's okay.
All right, thank you. Thank you.
I ain't worried, I'm gonna get mad.
Sean, you can you probably, and make sure she has her exhibits. The plaintiff, if they want them, that's.
Here's my mistake.
Yeah, just to.
Go down the elevator.
Those are her exhibits, Megan, if you could catch her at the elevator.
Yeah, those are the plaintiff's exhibits.
You want me to give it back?
Yeah, or they can wait for her to.
Down to the first floor.
Find out a place she can come and get them if she wants them.
I'll just meet her.
All right. And then I think we have an order for you to scan, Sean, when you're, but I gotta sign it.
I think I did, all right.
Dismissal. I think I have to put without prejudice, but it is with prejudice because of the way.
Okay.
But I'll go ahead. But we didn't, we just put dismissal. There you go, Sean. Oh, nice.